Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. Is Justice Clarence Thomas Black America's number one enemy? Let me ask you that question again. Is Justice Clarence Thomas Black America's number one enemy? And that's saying a lot because there are a whole lot of white supremacists who are high up on that list. But is Justice Thomas number one on that list? Now, as a member of the bar, I won't answer that question. But I'm going to give you some information so that you can answer it for yourself. Not based on emotions or hearsay, but facts. So, I want to begin with the definition of white supremacy. Now, this is a definition that took me many years to develop from lots of research, lots of reading, of course, my personal experiences, including being a civil rights attorney who fight white supremacy in court on a daily basis. So, let me give you my informed definition of white supremacy. All right, so I want to go to another screen. And here it is. White supremacy is a satanically backed global system of domination in which European nations and their descendants have long maintained control of power and wealth through interconnected institutions, systems, policies, strategies, and militarization designed to uphold a racial hierarchy that privileges whiteness and subjugates non-white continents, nations, and people groups, especially Africa and its diaspora. White supremacy is built on a lie, the false belief that was crafted and spread by Europeans and their descendants that God made them superior and gave them the right to conquer and rule over others. In other words, that is the justification for this white supremacy network. One of white supremacists' most effective strategies is using non-white operatives. These individuals are recruited, conditioned, deployed, and rewarded for betraying their own people while advancing the goals of white supremacy. Without them, these operatives, white supremacy would struggle to operate as effectively as it does against others, especially Africa and the African diaspora. You say, well, so why do I single out Africa and the African diaspora? Well, for two reasons. I am an African descendant, number one. Number two, Africa is filled with wealth and very, very valuable natural resources that nations around the world depend upon, especially European nations, have built their wealth from the continent of Africa, especially sub-Saharan Africa, where most of the blacks are. All right? So that's why there's such a focus from me, because it's such a focus for these European nations. All right? And contrary to this foolishness, that you see on YouTube, I am an African descendant. I've even checked my DNA. But even before then, I knew that I was a descendant. I am a descendant of African people from the continent of Africa. That doesn't mean that Africans did not sail to this continent before Christopher Columbus. Yes, I do believe that as well. But I am a descendant of the continent of Africa who came here pursuant to or during the transatlantic slave trade. I just happen to know my family history. All right, but anyway, back to Clarence Thomas. I'm going to share with you some info that's going to answer that question for you. All right? Here he is, Justice Clarence Thomas. I remember his confirmation hearing. I've read several of his books. I know where he came from and where he comes from ideologically. Okay? After all, I am an attorney. I studied and read many of his cases in law school. We read in law school just hundreds of cases, and we learn the law from what's in those cases. And many of those cases he has written. So you get to sort of know a person from the cases that they have written and that you read and have to read as a law student. All right? Now, I want to really point out that white supremacy, as I said, would not be as effective without operatives, without, in our case, black operatives, people who assist white supremacists and are rewarded handsomely for it quite often. So we have those people, and other non-white groups have those people. And white supremacy would not be as effective as it is without those operatives. All right, now, let's apply all of that, everything you just heard, to Justice Thomas and the Voting Rights Act of 1965 specifically. Now, the Voting Rights Act of 1965 was really the crowning achievement of the civil rights movement. No piece of legislation has had the impact on the African American community like the Voting Rights Act of 1965. And we have to take a moment and say thank you to the very courageous people who fought for it with their blood, with their sweat, their tears, through marches, and sometimes some of them gave the ultimate sacrifice. Of course, Dr. King, Medgar Evers, and others. I think about those three young men, Swerney, Cheney, and Goodman. Their last names, I can't think of their first names. All right? But today, there's a man on the Supreme Court, the man that you see sitting beside me here, who is the only black man on the court. And he is literally leading the charge to finish destroying, again, the crown jewel of the civil rights movement, the Voting Rights Act of 1965. And he is literally leading the charge to completely destroy what remains of the Voting Rights Act of 1965. You could say that he has declared war on the remaining sections of the Voting Rights Act of 1965. And see, if he wins his war, black voters across America will lose huge political power. I just think to myself, how can he, with a straight conscience, do that, knowing the sacrifices that our ancestors made fighting white supremacy, and it culminating in the Civil Rights Act of 64, the Voting Rights Act of 65, and other civil rights laws. How can he go to bed at night knowing that he's leading the charge, a black man from Georgia, against the Voting Rights Act of 65. Now, this current case started in Louisiana, but if Thomas wins this war, the impact will not be felt only in Louisiana. Potentially, the impact of what he's doing will be felt around the world. And I have to also throw in here, while I'm talking about people who work against the African American community, there are also content creators who I call pro-black imposters, who tell young blacks that voting hasn't done anything for black people, that voting doesn't matter, that they have the right to vote the couch. I disagree with that. When someone has sacrificed what our ancestors have sacrificed, and many of us still fight for today, no African American has the right to not vote or to vote to help white supremacists, and certainly don't have the right to attack the Voting Rights Act of 1965. So these pro-black imposters are just as bad as Clarence Thomas, maybe worse, because they have street credibility. Thomas doesn't have that. These pro-black imposters, they have credibility in these YouTube streets, unlike Thomas, okay? And that's because they look and talk like they're pro-black. They dress like they're pro-black. But some of them are, again, just as dangerous and cunning as Thomas. But I want to focus on Thomas in this video. I want to show you how he is using his seat on the highest court in America to help white supremacists destroy black voting power. All right, now let's take a look back for a second. After Selma, Congress passed the Voting Rights Act of 1965 to outlaw the racist voter suppression tactics of Southern whites. Various sections of the act have been targeted by different types of voter suppression, right? So we have had, for example, literacy tests, poll taxes, grandfather clauses, violence, and so on to keep our people from voting. That's how powerful voting is, regardless of what these pro-black imposters say. So there are various sections of the Voting Rights Act that are really, 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 really important. All right. For example, sections 4 and 5 of the Voting Rights Act, they work together against such things as poll taxes, literacy tests, grandfather clauses, and so on, by doing one simple thing. Those two sections working together required that Southern states get pre-approval, pre-clearance, before they can make any changes to their voting laws. And that was very, very effective at doing away with those voter suppression tactics. Did so well, in fact, that we have put a lot of people in Congress, and of course that culminated with Barack Obama being elected and reelected, as well as Kamala Harris being elected, and unfortunately she wasn't elected to the presidency. We were able, because of the Voting Rights Act, to elect her to become the first black female vice president. And that, again, is only because of the Voting Rights Act. All right? But Clarence Thomas voted with white supremacists to get rid of or to sort of dismantle sections 4 and 5 of the Voting Rights Act in a case called Shelby County versus Holder. All right. So 4 and 5, sections 4 and 5 were essentially gutted by the United States Supreme Court in 2013, and Clarence Thomas was one of those in the majority who caused basically the dismantling of those two sections. And so that enabled southern states, those notorious voter suppressing states, to re-implement laws, voter suppression laws, and use those laws against us African Americans. And it's the reason why we had a Trump 1 and we're dealing with a Trump 2 now. That was 2013. All right. 3 years later, Donald Trump won his first presidency. And of course, he has now been reelected. All of that is the result of voter suppression laws that were implemented after SCOTUS, with the help of Thomas, got rid of, dismantled those sections, section 4 and 5. All right. Now, sections 4 and 5, again, have been instrumental in bringing about the promise of the 15th Amendment, which says that our right to vote should not be abridged. But that meant nothing for 100 years until the Voting Rights Act was enacted. But the major sections, 4 and 5, Thomas helped white supremacists gut those sections. Now Thomas is working almost single-handedly to get rid of another really important section of the voting rights law, and that's Section 2. And what Section 2 does is it bans laws or election maps that dilute minority voting power. So Sections 4 and 5 dealt with individuals' right to vote. And it prevented, again, those states from passing laws that interfered with an individual's right to vote. Section 2 deals with another type of voter suppression tactics, and that is where whites will draw election maps that dilute black voting power. Okay? And they did so in two ways. Something in the law we call packing, and another something we call cracking. Packing is when the election map, those district maps, will pack a bunch of black people into one district. And then cracking is when they take the rest of the blacks in a state and crack them or disperse them in other districts so that their voting strength is diluted. It's not as powerful. So understand, so Section 2 prevents states from drawing election maps that both pack black people into one district, thus diluting our voting power, and then cracking the rest of black folks in a particular state across many different districts, thus diluting those voters as well. That's what Section 2 works against. All right? And it has been effective in doing so. And it's the reason why we have blacks throughout Congress, throughout state legislatures, local government, and so on. So Section 2 is really, really important. Section 4 and 5 are as well. What we need now, let me just talk about those for a moment before we go further. What we need now, because of Shelby County, is we need to get a Congress that is amenable to enacting the John Lewis Voting Rights Bill. I don't know the exact wording, but there's a bill that has been trying to get through Congress. The GOP continues to block it. That would repair the damage to Sections 4 and 5 so that those states would once again have to get pre-clearance before they change their voting laws. All right, because right after that Shelby County case, states like North Carolina, Florida, Texas, Georgia, these states began to enact other voter suppression laws. They're different from, the poll taxes and the literacy tests. They're different from that. They don't do that anymore, but they do it through voter IDs. What they're trying to do now is you got to prove your citizenship, all that type of stuff. In Georgia, they even got it where if blacks, if people standing in long lines for hours, you can't give them water or food or anything. I mean, all that is the new form of voter suppression that we could stop if we could get the John Lewis voting rights bill passed. And that's because the GOP blocks it. They block it. We can't get it through them. All right? So that really leaves Section 2. But again, Clarence Thomas wants to gut Section 2. He is working hard to strike down Section 2. Now, we see that being played out right now in Louisiana. All right, Louisiana. Black Louisianians make up 31% of the voting age population. Nearly 1 in 3 of the voting age people in Louisiana is black. 1 in 3. That's a third. Yet, for years, they only control 1 out of 6 of the congressional districts. All right? 1/3 of the voting age population is black, but they only control 1 out of 6 of the congressional districts. That's changed now. I'll tell you about it in just a second. But Clarence Thomas is trying to take it back. It was 1 out of 6 for years, and the NAACP and some other plaintiffs sued Louisiana and were able to get another congressional district controlled by blacks, where Clarence Thomas is now trying to not only take it back to 1, but he's also trying to gut Section 2, which protects black voters against packing and cracking, or what's called also racial gerrymandering. So he's leading the charge, literally leading the charge against Section 2. So make sure you understand the numbers. Blacks, 1/3 of voting age people, yet for years, they only control 17% of the voting districts. All right? That is an imbalance, right? You control, you represent 30%, a third, 33%, a third of the folks who are eligible to vote, but you only control 17% of the voting districts. That is not by accident. That is the way that they have been controlling elections for decades. And the thing that has helped us, again, make progress is the Voting Rights Act of 65. So it doesn't surprise us, or it shouldn't surprise us, that there are people who are trying to completely take it apart. They've been successful with that Shelby County case of gutting Sections 4 and 5. Thomas is leading the way now with Section 2. So, back to Louisiana. In 2022, the Louisiana legislature passed a map that preserved white control of 5 districts. And the governor at that time, John Bel Edwards, he vetoed that bill. The legislature overrode his veto. And then civil rights groups sued the state of Louisiana, and they won. A federal court ordered the state to create a second black majority district. And so that made the black majority control go from 1 district to 2 districts, following that lawsuit from the NAACP. All right. So that map gave blacks more voting power. And it was signed into law in early 2024. But white conservatives sued the state of Louisiana. So let's review what happened here. So for years, although blacks made up 1/3 of Louisiana's voting population, they only control 17% of the voting districts. So they sued and won. And a federal court required that they create another map and give blacks a second district that blacks were the majority in. All right. White conservatives sued. You could say white supremacists sued because they didn't like blacks getting another district. This time they claimed, get a load of this, this time they claimed that giving blacks another district, a second district, violates the Equal Protection Clause of the 14th Amendment. You heard it right. You heard it right. Whites are now using the Equal Protection Clause to propagate white supremacy. The Equal Protection Clause of the 14th Amendment was added to the Constitution to help us fight racism. Now whites use it to help propagate racism. Let me say it again. White supremacists are now using the Equal Protection Clause, which is to provide equal protection under the law for everybody. Whites are now using that clause to propagate racism. Because it is not racism for blacks to have 2 districts out of 6, that's 1/3, when they represent 1/3 of the voting population. That's only fair. If you make up 1/3 of the population, you should be in control of 1/3 of the voting districts. It'd be different if you make up 1/3 and you're trying to get 1/2. That's what they're doing. That's the racist part. They can make up 40, 50% of a state, yet control all the voting districts. That's the racism. And now they're using the Equal Protection Clause to further that racism. Now they're making that argument based on the fact that when the state drew up their SB 1 voting map, they considered the race of obviously of African Americans to create that second district. And they're saying that violates the Equal Protection Clause. In other words, if you take any consideration of race, if a state takes any consideration of race, then they're arguing that violates the Equal Protection Clause, even if the consideration of race is to help alleviate racism. We could see that it's a violation of the Equal Protection Clause if the state takes race in consideration to harm blacks, but if the state takes race in consideration to help blacks overcome racism, that is the purpose of the Equal Protection Clause. Okay, did you hear me there? It's important that you understand this. When you understand this, one benefit of understanding, the Bible says, in all thy getting, get an understanding. One benefit of getting an understanding is you cannot be deceived by these pro-black imposters. You can't be misled. You can't be miseducated. You'll know the foolishness when you hear it. All right? So again, the Equal Protection Clause was added to help us overcome racism. now white supremacists, with the help of Clarence Thomas, are using the Equal Protection Clause to propagate racism. I mean, it is that twisted nowadays. And again, Clarence Thomas is a key factor in them using the Equal Protection Clause against us. So this case has now reached the United States Supreme Court. And that's what it's all about. It is all about whether or not a state can consider race to end a racist practice and that not be a violation of the Equal Protection Clause. Clarence Thomas is in favor of finding that if a state uses race to address racism, it still violates the Equal Protection Clause. So he sees Section 2 of the Voting Rights Act and the way the court has used it to fight racial gerrymandering in conflict with the Equal Protection Clause. And he wants the Equal Protection Clause to destroy Section 2, the last remaining enforcement section of the Voting Rights Act. That is crazy. That is crazy, and especially for a black man. He wants the Equal Protection Clause to be used against Section 2 of the Voting Rights Act. Both of these laws and amendments, the amendment and the law, were both added to the Constitution to address, well, the Section 2 of the Voting Rights Act was not added to the Constitution, but it was enacted to address racism. They both were. They were added to address racism against African Americans. And he wants the Equal Protection Clause, again, he want to use it to basically gut Section 2. Because currently, in a case not long ago, the Milligan case, having to do with Alabama, the United States Supreme Court, even several conservatives, I think several of those conservatives, John Roberts, and maybe one more, I can't remember the specifics, but they said, no, you can use race to, you can use race with Section 2 to prevent racial gerrymandering and it not be a violation of the Equal Protection Clause. But Clarence Thomas, he goes further against Section 2 even than the white conservatives. At least one or two of them. Now, some of them agree with him because, again, he's carrying their water. This is what they want. This is what they've always wanted, to completely gut the Voting Rights Act. And if Thomas wins this war, then they would have gutted Sections 4, 5, and 2. And here's the thing. Some of these voting districts exist, some of our black voting districts exist because of Section 2. So if Clarence Thomas is able to use the Equal Protection Clause, it's hard to even hear myself say that, to gut Section 2 of the Voting Rights Act, then even some of these voting districts that exist now can be challenged and potentially gotten away with and done away with. We can definitely expect white supremacists, if he gets his way, to start filing cases against these voting districts that were created pursuant to Section 2. We can see white supremacists saying, okay, now that you gutted Section 2 in this way, those voting districts for blacks now should be done away with. So this is not just about Louisiana. And all of it is being led by a black man, Clarence Thomas. It is amazing. It's amazing when, in fact, the court in that Milligan case said that race can be used to effectuate Section 2. Thomas was furious. He wrote a dissenting opinion displaying his anger at that. Even back then, he disagreed with that. And so with this current case, and what has happened so far is it's reached the Supreme Court, but the Supreme Court scheduled it to be re-argued again. So it's going to come back before the court this upcoming fall term. And if he gets his way, Section 2 will be deemed unconstitutional based on, again, the Equal Protection Clause. Because in Thomas's view, even fixing racism is racism. Using Section 2 to fix racism, he believes, is racism because of the Equal Protection Clause, which again was added to the Constitution to fight racism. So those two laws, one is an amendment, obviously the 14th Amendment, the Equal Protection Clause within it, and Section 2, which is a statute, they should not be, as he's trying to do it, they should not be in conflict with each other. Because they both were created to fight anti-black racism. Wow, it all makes your head spin. I mean, this guy is just that determined to try to get rid of Section 2. Ultimately, that will hurt people who look just like him. In fact, I want to show you the last paragraph in his dissenting opinion regarding this Louisiana case, and you'll see how determined he has been for years to get rid of Section 2. Let's go there. At the very bottom, you see down there, it's highlighted. It says, for over 3 decades, this is Thomas talking, for over 3 decades, I have called for a systematic reassessment of our interpretation of Section 2. The court's decision in Milligan is the latest and most damaging installment in the disastrous adventure of this court's voting rights jurisprudence. I am hopeful. Notice he says, I am hopeful. For over 3 decades, he writes here. For over 30 years, he has been trying to gut the Voting Rights Act, a very important section, Section 2, over 3 decades. And so he says, I am hopeful. In other words, when the case comes back before SCOTUS in October of this year or during the fall term, he says he's hopeful. He's finally hopeful that he has convinced white supremacists, because those are the ones who are kind of resisting him. He's going even further than they want to go. But he says, I'm hopeful that this court will soon realize that the conflict is jurisprudence, it's Section 2, jurisprudence has shown with the Constitution is too severe to ignore, because the court declines to reach that conclusion today and instead inexplicably, without me understanding it, he's saying, schedule these cases for re-argument. I respectfully dissent. So he is just distraught that he was not able to convince enough of them this time to gut Section 2 using the Equal Protection Clause. So, brings me back to the question, is he the number one enemy of African American people? Is he? Because again, if he gets his way, not only would Louisiana lose its second majority black voting district, but it could impact other states as well. I mean, it is crazy. But that's what he's doing. So, let me connect the dots. This wouldn't be happening if those 3 additions to the Supreme Court had not occurred. Who? Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Who added them? Trump. When did he add them? During his first term. Who did he think for winning the election? Blacks. Why can't some blacks understand that Trump is a white supremacist who is working to dismantle black progress? Why do they think just because, whatever reason, he is a friend to black people? These young people quite often will show up on the channel and say that old stuff that you all are doing doesn't work anymore. That's the impact and the effect of pro-black imposters manipulating, miseducating, and misleading these young people, and it has had a detrimental impact on our community as these young people literally support white supremacy. You remember I said there's no way that white supremacy could be as effective as it has been without the help of operatives. And these young folks, without even realizing it, are being manipulated to be operatives of white supremacy. Let's read that again. One of white supremacy's most effective strategies is using non-white operatives. These individuals are recruited, conditioned, deployed, and rewarded for betraying their own people while advancing the goals of white supremacy. Without them, white supremacy would struggle to operate as effectively as it does against others, especially Africa and the African diaspora. So those are not only the Clarence Thomas types, the Byron Donalds, the Tim Scotts, and the rest of them, but those who masquerade as being pro-black, yet support Trump and MAGA. They too are operatives who help white supremacists. There's no way you can be pro-black and pro-Trump. No way. So you make the determination of whether Thomas is in fact the number one most harmful, impactful black person in the country against our community. All right? But I wanted to share this with you. This is really serious. And you need to understand what he's doing and what others are doing, just in a different way. All right. I am Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. And folks, wake up and then stay woke.